The House Committee on General Laws will come to order. Madam Clerk, please call the roll.
Chairman Riley.
Here.
Vice Chair Hicks. Here. Representatives Engel.
Here.
Baker. Here. Copeland. Here. Crossley. Here. Justice. Here. Labasco. Here. Mattison. Here. McMullen. Here. Meredith. Here. Myers. Here. Reuter. Here. Weber.
Here.
Having established a quorum, I now move that we will now go into executive session. I move that House Bill 419 be voted to pass. Any discussion? Representative Baker.
Thank you, Mr. Chairman. I have an amendment, ends in .11H. It is being distributed, I believe, and I move for its adoption.
Thank you, Representative. Please proceed with explaining your amendment.
Thank you, Mr. Chairman. So, most of these changes that are in this amendment are addressing concerns of various members of the committee. And so I'll just kind of go through these and explain the changes and then open it up to any questions. So the first one is it changes the name of the act from Missouri's Children Deserve Help Not Harm Act to Missouri Child and Adolescent Protection Act. It also deletes the word healthy from page 2, line 37. And it removes this limitation because the point of the provision there is the purpose of the procedure, not whether the body part is healthy. So it's also just, I think, excessive and doesn't really do anything on that word. It also tightens the definition of services being addressed by the bill on page 2, line 47 through 50, where it changes that definition to read physician services, inpatient and outpatient hospital services, puberty blocking drugs, cross-sex hormones, or genital or non-genital gender reassignment surgeries that are provided or performed for the purpose of assisting an individual with a gender transition. So it just tightens up that definition. It also clarifies that the bill will not prohibit mental health care services for individuals that are experiencing gender dysphoria or are diagnosed with that. It also removes the word, this is page 3, lines 66 through 69, removes the word physical from the phrase physical gender transition because that phrase is not defined in the bill, so it's unclear what that word is actually accomplishing. On page 4, lines 1 and 2, it deletes the stuff there about other state governments, federal governments, or foreign governments because we don't have the jurisdiction to do that. It adds provision protecting the state from having to cover the cost of transition procedures for prison inmates. And then page 5 just mirrors some language that is used in other parts of the bill. And then 9 removes language from page 6 regarding federal health care benefits. Again, because we likely don't have any jurisdiction to do that. And I think that covers the changes. So I would open up to any questions, Mr. Chairman.
Questions from the committee. Representative Engel.
Thank you, Mr. Chair. To inquire of the amendment sponsor.
Proceed.
Okay. So some of the concerns that we denoted during the initial public hearing were potential violations of the 14th Amendment, the Equal Protection Clause. It doesn't look like that's been addressed in this amendment at all, with singling out one population that's able to obtain medication and another that is not. What would you say to that?
I would say you're correct. It doesn't address it in this amendment.
Perfect. Thank you. I would also have questions regarding the amendment to section 191.1735, line 3. And that is, let's see, where you delete the said line on line 3 and insert in lieu of the following, the second part, an individual in the custody of a prison or correctional facility. Nothing in this legislation pertains to anyone over the age of 18.
That's
And
correct.
so I'm curious as to why we're now including adults and blocking their access to medical care. Because the entire premise, I thought, of this legislation was that we shouldn't allow minors to make these decisions, but by all means, adults should.
Sure. Well, I think it was to address concerns of some members, and that there is some concern that taxpayers shouldn't be funding those procedures for those that are in correctional facilities. And so that's why it was added to this amendment.
Okay, so if an individual is already receiving those services, and then they go into the correctional facility, and now suddenly they are abruptly not receiving those continued medical services, is there not any concern regarding the constitutionality of that?
I mean, I don't know. There would be several scenarios of which that could take place. It probably depends on what that looks like as far as what kind of care they're currently under and then going into the correctional facility. But I don't think it changes the fact that once somebody becomes in a correctional facility that then is taxpayer funded, then that's what we have the authority to look at when it comes to that funding. And so that's what I would say to that.
Okay, thank you.
Further discussion? Okay, Representative Lovasco, proceed.
Thank you. I just want to take a moment to thank the gentleman bringing forth this amendment, as well as the chair and the bill sponsor for being willing to have a discussion about how to make this bill better. I will admit that not everything that I would like to see is in this amendment, and I still have some reservations that we might bring down further the line when it comes to bringing this on the floor. However, I do think it is appropriate to acknowledge the fact that a lot of long, tireless hours went into trying to make this bill better, and even though it's not exactly what I would like, that effort is very much appreciated, and my vote today will reflect that. So just want to say thank you.
Further discussion? Representative Meredith,
To inquire the amendment, sponsor.
proceed.
Thank you. I respectfully disagree with what was just said. It seems to me that this actually just makes the bill worse, which I didn't know was actually possible. I got to ask specifically the deleting the word healthy. I think I heard you say you don't think that makes much of a difference, but what I see is that previously the definition was that surgeries to remove healthy functioning organs or other things was what was prohibited, but you take out the word healthy, so if I have a body part that has a cancer, it would still, I would not be allowed to remove it.
I would look at that differently, but
I mean,
Shape's
so
opinion.
words matter. The word healthy was there and then isn't there. So what is the impact?
maybe, I mean, this is language that I realize is technical, and it's a possibility that somebody else on the committee that has been a part of that conversation more than I have would be able to answer that question in a better way. But I think just in general, what I mentioned earlier is that the point of that provision is the purpose of the procedure, which is for transitioning, not whether that body part is healthy. So that word just seems excessive and doesn't really do anything as to what that provision is lined out for there.
Well, it strikes me as there was a reason to take out the word healthy, and the only thing I can think is a scenario like that where it's an unhealthy situation. Similarly, though, and I think this is where it gets to the heart of the concern, when you get to the section you added about mental health care services for individuals experiencing gender dysphoria, that's an exception, right, of services that are prohibited. Mental health services for individuals experiencing gender dysphoria. I appreciate that being in there, but what about mental health services for anybody else that is dealing with the question of a transition.
I don't think it would prohibit that.
So again, where words matter, it specifies which ones, and these are the only exceptions given. I think that I'm very concerned that that actually suggests that other mental health services are included in physician services at the beginning that are involved in assisting an individual with a gender transition. Well, if somebody's going through a gender transition, legal or not, and they need services like mental health services, are we preventing somebody from providing those services?
I don't see it to be that way.
I would encourage you to read the words, because I think that's what it does. But then similarly here, so that actually took out a different exception. And I'm not sure we really addressed that. Any procedure undertaken because the individual suffers from a physical disorder, physical injury, or physical illness that would, as certified by a physician, place the individual in imminent danger of death or impairment of a major bodily function unless surgery is performed. Previously, this at the very least had an exception for if imminent danger of death or impairment of a major bodily function unless surgery is performed, that those surgeries would be allowed. You're taking that out?
So you're talking about on page 3?
Lines 66 to 69 that are deleted here. So we don't want an exception when someone's life is in imminent danger?
So the only thing I see taken out is the word physical.
So on lines 14 of your amendment, further amend said bill and section, page 3, lines 66 to 69, by deleting said lines and then replacing it with the mental health services
Oh, sorry, I was
exception.
looking at the wrong place.
That's a fairly massive exception to get rid of. If this is supposed to be about child and adolescent protection, if they're in imminent danger of death or losing a bodily function of a part of their body and they can't have surgery, why did you delete that?
I'm trying to figure out exactly what the differences are there.
Representative, I'll just go ahead and hop in for a second. We will take a look at that and see if we need to make some changes for the floor. So I'll just give you my commitment that I'll work with the bill sponsor to see if there's some language changes.
But in the meantime, you're going to vote for an amendment that deletes a protection for imminent danger of death?
We are going to vote on the amendment today, but again, we'll take a look at that. So I understand your position. I'm just telling you what my commitment is to you and at this point, because I hear what you're saying.
The last question. No, not the last question. This title is Missouri Child and Adolescent Protection Act. How does doing anything about prisoners and their ability to get medical care have anything to do with child and adolescent protection?
Again, I think it fits into the scope of the bill as to the nature of what is being addressed. As far as the title of the bill, it may not be something that's exactly falling under that very tight title, but I think that it falls into the scope of what we're trying to address here.
I struggle to see how, but I'll ask also about on the second page of the amendment, the adding the based on an actual or threatened violation of. So this is about somebody suing for a violation of this bill. And I believe it gives a minor 30 years later to be able to sue. But this also makes it so they can sue for something that wasn't even an actual violation of this statute? Just a threat of one?
That's how it reads.
Why?
So what page is that on?
It's the second page of your amendment.
So what was the question again?
Why?
Why?
Why are you making it so that somebody can sue over not even an actual violation of this law?
Obviously, I think that was something that somebody had a concern about and wanted to put.
This
put
is
into
your
the-
amendment, right?
Yes, it is.
Can you tell me why these things are in it?
There's a lot of discussions that went on with this, so, you know.
And
again,
can
if
anybody on the committee tell me why these things are in it?
They may be able to.
Thank you. Mr. Chair,
Representative Meredith,
just to speak against the amendment.
proceed.
As I said, I heard it suggested that this amendment was to try and make this bill better somehow. And all I see is things that are actually harming more people. I think it would be incredibly irresponsible of us here to vote this out and say, well, we'll just fix it later. Frankly, it's irresponsible for us to vote this out at all, but we can have that conversation after this amendment. But I would appreciate if the committee would do its job here, and rather than on short notice looking at an amendment that we don't understand, not passing that. Thank you.
We are going to stand at ease for a few moments and stand at ease, right, for a few moments as we work to address one of those issues that Representative Meredith raised that I think that I agree with and I think may have been an oversight. So we're going to make that fix and we'll stand at ease for a few moments and have a new amendment that addresses that item momentarily.
Oh, yeah.
Or was legal. Yeah. There are so many. Ridiculous.
Yeah, he's wrong about that.
Okay, we are going to come back to order. The bill sponsor has a few thoughts on the amendment in front of us right now that he would like to discuss. It's a little unusual. I don't like doing this and certainly won't make a habit of it. But in light of the conversation and the weight of these bills and the importance of them to the bill sponsor, including the amendment in front of us, I'm going to allow him to come forward, explain his position, especially with respect to the item raised by Representative Meredith. I will open it up for a few questions. We're not going to go long on it, but I am going to allow him to present and will allow the committee to ask a few short questions to the bill sponsor. Representative Hudson, please come forward and share your thoughts.
Thank you, Mr. Chair, members of the committee. For the record, Brad Hudson, State Representative District 138, sponsor of House Bill 419. I wanted to especially address the concerns that Representative Meredith had mentioned with regard.
I'm going to interrupt you just real quick, and just to focus in on what we are discussing, the only topic that we're going to discuss in this exchange is the item regarding the language on page 3, lines 66 through 69, in the portion of the amendment striking out that language. Okay. With that being said, apologies, Representative Hudson. Please proceed.
Thank you, Mr. Chair. So the particular language that we were talking about earlier has to do with the removal of that particular exception that Representative Meredith is concerned about. And I can appreciate his desire to make sure that no one does not have access to any medical care that they may need in order to save their lives. This exception is not necessary for that to take place. This bill is all about gender reassignment surgery. And the reason that that needs to be taken out, and it does, is because it could be an exception that swallows the rule. You don't want a situation where some folks might say that there is, because of a likelihood of suicide or a likelihood of this, or that they would actually subject children to these drugs and or to these surgeries and try to use that as an exception, when the reality is there is nothing in this bill that would not allow someone to get the life-saving care that they would need if they have a part of their body that needs to be removed. They're not doing that to change their gender. That's not a sex change. That would be like an amputation procedure to save their life. And I'm happy to take questions if there are any.
Questions from the committee? Okay, seeing none. Representative Lavaska.
McGuire.
Proceed.
So I think I kind of understand what you're getting at here. I guess the question becomes, does not change the scope of the bill as far as how we're kind of looking at it from the start, from one of what types of procedures are appropriate to what someone's reasoning for those procedures are. Doesn't that kind of change the analysis of other sections in that light? I'm not sure that we were ever really getting into whether or not someone has a good reason for making these decisions. It was simply certain types of things are appropriate in certain conditions and certain things are not. If we remove this exception, aren't we effectively saying that someone, their rationale is somehow at play? Or are we not opening up a door we perhaps don't want to open?
No, Representative. I don't see that we're doing that here, because what this bill is about essentially, these kinds of drugs and surgeries being given to or performed on minors, and gender transition procedures. That is not, this bill doesn't touch on necessary health care to save a human being's life. So I guess I don't totally understand your concern. Would you like to repeat it in a way?
Yeah, in other words, if you're saying that this section doesn't need to be in there and in fact maybe undermines parts of the bill because the bill only applies to elective procedures and not things that are necessary, well, then aren't we in a position to basically determine whether or not something is necessary or elective before the bill even comes into play? Which is a whole different discussion. My understanding was the whole purpose here was to just kind of set guardrails around what types of procedures are appropriate for children regardless of circumstance, in which case I do think we need to specify that if it's for a life-saving circumstance, it needs to be allowed.
Well, I appreciate the fact that you think that needs to be specified, Representative. I think myself it's being redundant because I think the bill itself does not, as it would stand alone away from that section, does not prohibit that kind of care. I don't think that's an area we're treading in here. I think we're trying to be very specific with the portion of my bill that I brought before you when we had this hearing late January or whenever it was. We're trying to be very specific with regard to certain procedures and drugs that minors under the age of 18 shouldn't be subject to. So I respect.
I agree, but I guess my concern here is if the worst case is some redundancy, shouldn't we err on the side of caution when it comes to these types of situations?
I appreciate your concern, Representative, and I would, of course, have no problem with being redundant if it made you comfortable. It wouldn't be necessary for me, but if it made you comfortable, as long as we had a guarantee somehow that there wouldn't be some individual within the medical community that would try to use that particular exception to do the very thing that we as a legislature would be saying you should not do to children.
Well, I think I'd argue anytime lawyers are involved, there will be someone who will find a way. I don't think we're going to word our way into every possible circumstance. I think the best we can do is cover most of the bases.
And I appreciate that, Representative. And I would just respond in saying that your belief that lawyers can find a way is not one that I would argue with. It is not my desire to give them more of a beaten path than they already have, though, and that's kind of my stance on this. Why I don't have a problem with this. Anyone who knows me, Representative, and you wouldn't argue with this.
I know your motives are pure here. I'm not.
There's no way that I would want to support legislation that would not allow individuals to have life-saving surgeries that they needed. No way. And if I thought for a moment that this exception was necessary in order for that to be done, I would be all for it. Right now, I am expressing to the committee that I do have some concerns with that exception, and I believe we're on very firm ground with it not being necessary.
I think that's a fair point, and I think my position is, given that this is something that was discovered mere moments ago, I think the safe choice is to add the exception back in, and after further deliberation, if we decide, you know what, we don't need it after all, maybe removing it on the floor is a discussion that can be had rather than the other way around. I think that would be what I would be comfortable with. But thank you, gentlemen.
Representative Engel.
To inquire.
Proceed.
Okay, so this initial exception was in your bill, was it not?
Yes.
And you've since had a change of heart on that exception?
Yes. Well, I wouldn't say change of heart. My heart is in the same place it's always been. Representative, I'm sure at times, maybe you haven't, but I know many of us in this body have brought forth legislation as it makes its way through the process, as we have conversations with other members, with other individuals that care about the legislation. There are certain issues that can arise, and you can say, you know what, that's a good point.
Okay, so someone brought this to your attention and
Yes.
changed your mind about it. Okay. So I kind of want to piggyback off of what Representative Lovasco just said about this assumes that we understand people's intent. I think when we remove that language and that we are calling into question the reasons why people would obtain surgeries. And so I do agree with that. I also think it's important to understand that are you familiar with dual diagnosis, that people can have multiple diagnoses happening simultaneously? And so you could have a child with gender dysphoria that also has uterine cancer.
And absolutely nothing in this bill would not allow that child to get the health care they needed.
I disagree with that, because I think that when we remove that imminent piece, I think that now we introduce, certainly hospital attorneys who are going to be fearful of retribution and of lawsuits. I think that this is, once again, a tort nightmare. I think that if we are truly pro-tort reform in the state, then we want to delineate what hospitals and what medical care folks are able to obtain in this state.
Representative, if I could just respond, and I don't know how I can more emphatically
state this and yet still remain with the proper decorum we should have here and showing you the proper respect you deserve as a member of this committee. I totally disagree with you. I totally disagree. There is, and you know me, Representative. I know you. We were elected at the same time. I think you know where my heart's coming from. I think I know where yours is. And this is an area that I don't see.
Our intent can be great, but intent doesn't equal impact.
I understand.
So we've got to look at how this is actually going to be applied. And, you know, we have lots of examples of hospital and healthcare systems having questions regarding a lot of legislation that we've passed in the last couple of years on what they're able to offer without getting hospital attorneys involved. And so when we're talking about imminent need and we're talking about imminent danger, I think that I agree with Representative Vosco, although I'm not supportive of the bill or the amendment, that I think is really important language to leave in.
I appreciate your concerns, Representative. I would just respond by saying that I have all the confidence in the world that the way the bill is written, even without the particular piece of language we're discussing it, I think individuals in the healthcare community should be able and would be able to see what this legislation is speaking to. And I don't think the exception is necessary.
Okay, thank you.
Briefly, Representative Meredith.
Just to briefly comment then. I think the situation we're looking at here and why these exceptions are important is when we have it be tied to motive for having the care, as Representative Levasco pointed out, we create a situation where there may be kids who have multiple reasons for needing a particular surgery or treatment. And when one of their reasons is gender reassignment, that may actually prevent a doctor from being comfortable providing necessary health care for other reasons. So they see two necessary reasons they're looking at that they've decided this child needs this care, but because one of those reasons is turned into a crime, they now can't provide it at all, because even if they have another reason that is allowed under the law, they're going to be at risk of having committed that crime. And lawyers for doctors, as we know, are going to take conservative approaches to mitigate risk. If there's a risk they're going to be committing a crime, we may have kids not getting care for a whole lot more reasons than the one reason you're attempting to address in this bill. Thanks.
Just a couple quick questions from me, Representative Hudson. You were requesting for us to, just so I'm clear, to vote on the amendment that Representative Baker has provided to us, and you have given us the reasons why you think that it's important to exclude this language at page, on page 3, line 66 through 69, correct?
I think that is a fair characterization of what I'm asking.
And as this bill continues to move through the process, I know you and I have worked closely on this, had a lot of hours in conversation, as have these committee members. And would you be willing and comfortable to give us your commitment today that you will continue to look at this issue, and if you believe some additional exception language is needed, that you will work with the General Assembly, with the Missouri House to effectuate those changes?
I am absolutely willing to do that, Mr. Chair.
Thank you, Representative Hudson.
Thank you.
Seeing no further discussion, all those in favor of adopting House Committee Amendment Number 1 signify by saying aye. The ayes have it. Further discussion. Representative Engel.
To comment on the bill.
Proceed.
So one of the amendments, part of the amendment that I brought into question was line 30 on page 1, where we're adding an individual in the custody of a prison or correctional facility. There's absolutely no language in that denotes who is paying for that. So the I mean, just the real simple reading of that would mean that you would not be able to use your private funds, you would not be able to use private insurance in order to continue your own medical care. So it's not just blocking taxpayer-funded gender treatment. It is blocking folks within the DOC from obtaining medical care, period. I think that there's absolutely constitutional issues with that, and I think it's incredibly short-sighted that we just introduced an entirely different population and didn't have any discussion of insurance or payers and payment into this debate and into this bill. I have tremendous concerns about that. I have tremendous concerns about the fact that we have folks who could have possibly already had gender reassignment surgeries prior to being incarcerated and have legally changed their sex. And now we are going to be denying them treatment that they're possibly privately paying for, and introducing a slew of litigation into that. And so for a body that continuously talks about autonomy, bodily autonomy, medical freedom to access the services that you deem to be appropriate for yourself, now we're introducing people over the age of 18, and we're saying that they cannot access care that they have already established. Because once again, this does not say tax-funder paid insurance. It just says an individual in the custody of a prison or correctional facility. So I want you all to think about that when you talk about personal freedom and medical freedom. Thank you, Mr. Chair.
Representative Meredith,
To comment.
proceed.
Thank you. So our committee sat through 9 hours of testimony on this bill, and bills like it. That testimony was powerful. We all sat through it. We all got to hear from parents, from kids, from adults with personal experience with this issue. We got to hear from doctors and representatives of the medical community with expertise and knowledge on this issue. It was pretty obvious in that hearing that the folks behind this bill don't actually have an understanding of either of those things. They didn't even stay for the testimony. They said they didn't talk to any of those doctors or medical community experts. They didn't talk to any of those families, the parents, and they didn't stay to listen to them. We did, this committee, which means it's our responsibility to reflect on that testimony and learn from that testimony and act on that testimony. Because guess what? If we pass this out of this committee, it's going to a floor where most of the rest of those folks did not hear that testimony. Most of the rest of the folks that will be voting for this on the floor did not sit through compelling hours of testimony. Now, I don't know about you all, I was drained emotionally after that hearing. It was tough, it was a lot. The next day I was still drained. When it was time to go home, I got a text message shortly before my committee ended that my daughter was going into the hospital with a seizure. And I found myself rushing home to get to the hospital to take care of my daughter. I found myself in tears thinking about my daughter, but also thinking about those parents from the day before. And imagining that I'm driving home to deal with my daughter's emergency healthcare situation and wondering, what if the government, a bunch of politicians who don't know anything about my daughter's health, who don't know anything about the doctors, who haven't met with the doctors, passed a law saying I couldn't give the care my daughter needs? That I couldn't go home and take care of my daughter and save her life because some people out here had a moral objection to what my daughter needs and what her doctors and the medical community say she needs. You all heard those parents in that committee. They love their children deeply, passionately, fiercely. They've been through countless hours of therapy, of doctor's appointments, not just in St. Louis or Kansas City or all across Missouri, all across the country. They are desperately trying to do what is best for their children. You all got to sit and listen to them talk about that. Do you want to be the ones today to vote to say you know better than those parents? You know better than those kids and their doctors? That government should be the ones telling them what's best for their kids. Is that who you want to be today? Because I'm begging you, this is our best chance with people that actually paid attention and listened to the testimony to actually respect those parents and their rights and those kids and their lives. Please don't think a yes vote today and allowing it to go to committee or to the floor and you'll vote no there is doing your job or respecting those parents or respecting those kids. It's not. Please vote no.
Thank you, Representative. And seeing no further discussion, I now move to roll House Committee Amendment Number 1 into a new House Committee substitute and adopt the substitute. All those in favor signify by saying aye. Aye. All opposed say no. No. The ayes have it. You have adopted the substitute. I now move that House Committee substitute for House Bill Number 419 be voted do pass. Any discussion? Representative Velasco.
So 45 minutes ago, I stated that I had really appreciated the work that's been done on this bill and that that had gotten me to overcome some of my concerns. And then the last 45 minutes happened. And I got to tell you, this is not going to go into effect until August no matter what we do. I have heard the 9 hours of testimony, and I am convinced that we do need to do something, that there is an important role for the state in this space. I am not convinced that we need to rush into it. I'm not convinced that we need to go forward regardless of whether or not it's 100%. I do think the role of committee is to vet bills and get them to a certain stage, and it's not the final stage. It doesn't have to be perfect. And I'm usually inclined to think that if we're close, I ought to be a yes and we fix the rest on the floor. I was on that fence this morning as to whether we were close enough, and you know what? I'm off the fence now. I don't think we're there. I'm not a no because I do think we need to do something, but I can't be a yes either. So I guess I'm going to have to punt and be a present for the moment, and we'll talk with the bill sponsor, see where we can get. But I got to tell you, we want to get this 100% right, because if we don't, there's going to be problems. So I hope everyone will commit to working on this and making sure that we don't make any mistakes. So thank you, Mr. Chair.
Thank you, Representative. Seeing no further discussion, Madam Clerk, please call the roll.
Chairman Riley. Vice Chair Hicks. Representatives Engel. Baker. Copeland. Crossley. Justice. Lovasco. Mattison. McMullen. Meredith. Myers. Reuter. No. Weber.
By your vote of 8 aye, 5 no, and 1 present, you have passed House Committee substitute for House Bill number 419. We will now move into executive session on House Bill 183. I move that House Bill 183 be voted to pass. Any discussion? Representative Baker.
Thank you, Mr. Chair. I have an amendment ending in point 03H, and I move for its adoption.
Please proceed with explaining your amendment.
Thank you, Mr. Chairman. This amendment for House Bill 183 basically has two substantial changes to the bill. It will make it to where it will also apply to private schools and private colleges and universities, as well as public colleges and universities, but it exempts below grade 6 of how the bill would apply. And then on the penalty provision, there's a few changes there. There's a tiered system, penalty system, where DESE will withhold a certain percentage of the monthly distribution, which increases per violation. So 25% for first violation, 50% for second, 100% for third violation. And then with the public institutions, and so that's a withholding penalty. On the public institutions, it will be a fine with similar tiered penalties. And then there is a cap on private colleges of up to $1 million for violations. With that, I'd take any questions.
Questions from the committee? Representative Engel,
To inquire of the amendment sponsor.
proceed.
Okay. Let's start with, why are we changing it to grades 6 to 12?
So I think that, was to address some concerns from members that thought the physical abilities at those ages were not substantially different.
Okay. So we're okay with boys and girls playing together until grade 6?
Some would say that.
Okay. So you can play on whatever team you want until then?
That's how the bill would read, yes.
Okay, cool. Let's talk about those penalty provisions. So one of the most interesting amendments I saw was the inclusion of private post-secondary educational institutions. So I'm looking specifically at page 2, line 35. Any private post-secondary educational institution that violates subdivision 1 of subsection 2 of this section shall be fined up to $1 million per violation as determined by the Coordinating Board of Higher Ed. So we're going to start fining private schools $1 million, I'm guessing, per violation? Is that right? So are we going to start governing them in that way now?
That's the way the penalty would read. I think there was an effort to try to have a penalty for both, and that's what they came up with.
So if I'm a private institution, I'm a private religious institution, and part of my religion is to allow transgender kids to play together. That's a core tenet of my faith. How is this not a violation of the First Amendment?
I would suppose that would be left to the courts to decide.
Well, the courts, we're going to keep them busy, aren't we, with these bills? Okay, but we're fine with that, right? We're fine with fining private religious institutions $1 million per violation for adhering to the core tenets of their faith. I have a lot of amendments that I would like to add to that section on the floor, for sure.
You'll have your opportunity.
Okay, thank you.
Representative Vasco,
Thank you, Mr. Chair, to make a statement.
proceed.
Thank you. So I'm not sure that that's a First Amendment violation. I would say it's a violation of the role of government. We have no reason whatsoever to regulate a private school in this regard. This is not a safety issue that rises to the level of our interference. I would argue that free market principles would suggest we would want private schools to be able to do that. The argument being is that if we want to say that taxpayers aren't going to fund it in public schools, that the market can adjust and decide that if other leagues are going to pop up where rules are different, then that should be the market deciding. If we're saying that literally nobody can do this, I am very uncomfortable with that, and quite frankly, I see that being well outside the scope of this bill. So I am very much opposed to this amendment, and quite frankly, would be opposed to the bill if this makes it on there. So that's my thoughts.
Additional comments, questions? Seeing none? Oh, I'm sorry, Representative Reuter.
Yes, thank you. I just noticed that the amendment does not, as it pertains to the intercollegiate athletic games and their restrictions, there's no genome requirement there. And why is that?
I wasn't aware of that. What line are you talking about?
Yeah, if you compare on page 2, lines 14 through 16, it says, except as provided under subsection 3 of this subsection, no post-secondary institution shall allow any student to compete in an athletics competition that is designated for the biological sex opposite of the student's biological sex. And if you compare that to the bill itself, they have both, that would be on page 1, lines 5 and 6. Sex is defined here as divided based on individual's reproductive biology at birth and the individual's genome. So I'm just wondering why there's a disparity there.
I think if you look above there on line 10, it is defined in that.
Thank you, I missed that.
Seeing no further discussion, all those in favor of House Amendment Number 1 signify by saying aye. Aye. All opposed say no. And the ayes have it. Further discussion. Seeing none, I now move to roll House Committee Amendment Number 1 into a new House Committee substitute and to adopt the substitute. All those in favor signify by saying aye. Aye. All opposed say no. The ayes have it. You have adopted the substitute. I now move that House Committee substitute for House Bill Number 183 be voted do pass. Any discussion? Seeing none, Madam Clerk, call the roll.
Chair Riley.
Aye.
Vice Chair Hicks.
Aye.
Representatives Engel.
No.
Baker.
Aye.
Copeland.
Aye.
Crossley.
No.
Justice.
Aye.
Lovasco.
No.
Matheson.
Aye.
McMullen.
Aye.
Meredith.
No.
Myers.
Aye.
Reuter.
Yes.
And Weber.
No.
By your vote of 9 yes, 5 no, you have voted House Committee substitute for House Bill 183 do pass. And that concludes executive session and concludes the hearing on general laws.